started with our final presentation. So Elizabeth, I will turn it over to you.
Okay, let me make sure everything is good. Andy, since you're still maybe audible, can you hear me okay?
Yeah, everything's good.
Okay. And the screen is okay too? Okay,
Yes.
cool. So, um, thank you to everybody for participating in our CLE, our first annual general CLE offered by West Tennessee Legal Services. My name is Elizabeth Duke. I am our senior services attorney here at West Tennessee Legal Services. And I am going to be talking about, we're calling them essential documents. You might call them like estate planning documents. But the kind of purpose of this program is looking at doing simple wills, power of attorneys, and advanced directives. And I'm looking at from an angle of working with clients who don't have a lot. And that comes from my perspective of working here at West Tennessee Legal Services. So we'll talk a little bit more about what I am going to cover, what I'm not going to cover. So if you decide to bounce out of this CLE, I'm just giving you an option to do so. So brief introduction. I didn't put anything about me, but again, my name's Elizabeth Duke. I started here at West Tennessee Legal Services in 2019. Um, I started I was a law clerk in the senior unit, so I was helping draft these documents for all that time. And then when I became an attorney, I rolled into the program. And so all of my clients under these various grants, most of my clients are over the age of 60. And I do a chunk of these for my practice is just the basic wills, advanced directives, and powers of attorney, and then educating about them. So that's the documents that we're going to be covering. I will also say this program, I'm going to be doing a lot of like practical considerations of when you meet with clients, what you need to know. Just kind of thinking, I'm going to be kind of putting in things, thinking through if you're volunteering as a pro bono. I certainly hope that you're able to take kind of information and apply it to your own practice. But and then I have a little asterisk on the screen that says we're doing this through West Tennessee Legal Services. So there's multiple legal aid organizations throughout the state. West Tennessee Legal Services often has virtual options to do pro bono work in this field, specifically these clinics where we help with these these three essential documents. But if you know locally, there's a possibility that your local legal aid or legal services will have opportunities as well. So this is just a little caveat coming out of West Tennessee Legal Services. Something else to consider that we'll go over is that what we do, our role is really just a small portion of advanced care planning, right? So, and we're going to talk about that. And then just some considerations, ethical considerations, thinking about capacity, competency, undue influence, family members, and then really just kind of being mindful of who your client is through this whole process. A real quick thing, I'm just the things that I know I'm not going to cover are just like trust documents, living trusts, power of attorney for healthcare, any kind of documents that are specifically drafted for minors. Everything I'm looking at is for adults. Living wills, complex wills, holographic wills, any type of complex estate planning. This is like essential documents 101, and that's what I want you to know kind of entering into this. So, let's see. I am going to try something for the sake of participation. So if theoretically a poll has popped up on your end and there's 3 questions, okay? So the first one is my experience with estate planning documents is, and your choice is you can say you've drafted these in the past, you draft them regularly, but you want a refresher, you have no experience, and maybe we covered this in law school, but who's to say? Um, and then down here, I personally have the following documents: all or none, power of attorney, advance directive, or will. And then, so I did it. I'm trying to see how I can pull up these short answers, and it might have to be when the quiz is over. But what are reasons clients should have these documents in order? And so I'm going to have you just any reasons that you have. And it looks like um, so far we have 7 out of 39 that are participating. Oh, eight people have participated. So again, if I get it, like, so I'll leave it up for probably another minute, and let folks just it helps me get a sense of what you guys like, where you're coming from. Okay. I appreciate that we got almost half of the participants seem to have their documents in order, but a handful don't. All right, so 30 more seconds. If you're not participating, this is your opportunity to join the poll. And I'm not sure how that looks on your end. I can see how it looks on my end, but I'm not sure how that looks on your end. Okay, so I'm about to end the poll and then I'll just see what reasons we've got. And okay, all right. View the details. Let me see if I can see this. Oops. Okay, so well, I can pull this over here so everyone can see it. Andy, can you see, like, if I pull it onto that screen, can you see it, or is it only
Yep.
sharing the program?
No,
Can you
I
check for
can't see
me?
it. We can see it. Or
Okay,
I
cool,
can.
thanks. Okay, so lots of people have drafted these in the past, several draft regularly, and somebody is brand new, and that's great. Okay. And then the documents, and then I do this one: peace of mind, save money, responsibility. They are essential, make their wishes, cares, like for protect themselves and for planning purposes. Okay. Thank you for participating. Let me try and get this out of the way. Result is done. Back. Sorry. Okay, cool. So, the advanced care planning, I have a longtime friend of mine, is just a recent PhD graduate out of Vanderbilt University, did her dissertation on advanced care planning for low income populations. And so she spent a whole lot of time studying, looking at like cultural differences, looking at what are like barriers. But she's coming from entirely the healthcare perspective. And so she shared this with me, and I know that there's a citation for it. If you are truly interested in that citation, let me know. I will have to follow up with her. But I like this graphic because it really kind of shows we're just a small role in the idea of our advanced care planning, right? Attorneys play a very small role, an important role, a very important role, but it's still small, right? And so when it comes to whatever you call it, estate planning, end of life planning, advanced care planning, there's this pre-contemplation and contemplations where there's kind of raising an awareness, addressing fears or biases, and what kind of barriers might exist. And then the contemplation, so we're working on educating the public, reflection of goals, values, and preferences. Um, and I think something that's important to whether it's through this lens, the healthcare lens, um, be mindful of like client centered, or in the medical field, the patient centered. And so, and then preparation and action. And so that's where we would come in, right? So where we're actually preparing the document. So now that, when they have the opportunity to be thinking about it and contemplating it, then they come to us, and we're able to prepare the documents for them. And then the maintenance. And I think that's something that's also important, because I run into seniors that say, yeah, I have all these documents. They're 15 or 20 years old and my husband's now dead, but I still have all these documents. Well, that's why this maintenance comes in, right? Kind of revisiting, do the documents still apply? Is your agent still someone you want to serve as your agent? Is your agent still alive? Lots of reasons why, kind of to think about that. So West Tennessee Legal Services does a decent amount of, and I know this goes with other legal aids as well, outreach and education. I know there's some private attorneys in our area that do a good job on like Facebook, kind of sharing these for their purposes, just kind of creating an awareness. But we're kind of working in tandem with us and then the medical field. Hey, there's these things that we have to think about, as a society, as a community, as an individual, and at what point does the attorney step in? So, one organization, and Andy, I'm going to let Andy share in the chat box because I'm not good at focusing all this stuff. But there is the National Hospice and Palliative Care Organization has, I think, an excellent resource for family members family members and individuals. And so he just shared that in the chat. Family members and individuals to start thinking through this. So I think maybe one of the barriers that I encounter a lot is family members not wanting to talk about this. And whether it's because they don't want to admit that death is reality, they don't want to think through the difficult things that may happen to family members. Um, I had one client that she said, "I'm not 75 yet. I don't need these documents." And so and like that somehow that only older individuals need to have these documents. So I think it's helpful to pull in resources that are not necessarily attorneys to encourage these conversations to kind of fuel that pre-contemplation stage and the contemplation stage before we go in. So I know I already asked this. I'm going to ask one more. This is another poll and just trying to make this interactive. Specifically, if you are talking to clients, particularly ones that are doing this routinely, what are reasons that you tell clients to have these documents in place? And I had a few people like ease of mind. Um, it's less expensive, but I'm just opening it up. If there's any other, what are reasons you tell clients to have these documents in place? Or do you not? That's why we're here. Elizabeth, we need to know what to tell our clients. Just kidding. So I've opened the poll. Okay, one person answered. Thank you for that one person cooperating with me. Okay. Move this. I'll give a few more. And I'll just continue. I think, and especially because my work is almost exclusively with an aging population, I like the first thing I'm always being mindful of is their own dignity. And I think, and the reason that is because I hear it all the time. And I think if you look at what kind of support systems are in place, if you look at how our society treats aged individuals, dignity is often the most important thing. And so when I give presentations, one of the first things that I tell people is that when you are able to, you get to make these decisions. This is for your dignity. Okay, I'm going to go ahead and end this poll. Thank you for the 10 participants. I appreciate you. Now let me look at these details. Let's see what we got. Peace of mind. It is a nightmare for a family if you don't. We'll talk about that. So that in case they can't make a decision when needed, it helps those caring for you. It saves your family. It protects yourself. It does make things easier on loved ones. Protects your children. Yeah, so just, I mean, really, these documents, the idea of these documents I'm hearing over and over again is that it makes it easier, right? So we have the dignity idea, we have the autonomy. You're going to get to make your own decision, right? If you think through what is the alternative, if you don't have a power of attorney in place, or if you don't have an advance directive in place, what is the alternative? As something as severe as a conservatorship, and that may not be what you want, right? This said, a lot of people said ease of mind, ease for family members, ease for care providers. It is less expensive to do it this way. It is less of a heartache or a hassle, especially if you have ever had a family member, if you've ever had to deal with these things without the documents in place. It is a mess. And that's where this prevention of future litigation, whether it's um, going through a conservatorship process, whether it's moving to appoint different people. I mean, COVID, I think, was probably the biggest example for me, and I almost always now with my presentation start with that because, I mean, truly, we use the word pandemic now, but think back to February of 2020, this word pandemic didn't really mean much. And I can't tell you the number of clients who would call us. My wife's on a ventilator, and now I can't access our bank accounts. And what are you supposed to do with that? And so that's where, and it happened so quickly, and you just never know. And that's why this is where like kind of the biggest thing when I'm sharing with clients, like, doesn't matter your age, you should have these documents in place. So thinking through our clients' needs, one-on-one conversation. So have conversation when you're meeting a client. So I know that, again, I've talked about this being kind of thinking through if you're a pro bono attorney, if you're looking to do this kind of as just a side service, these are really easy to complete. Makes you feel good. You help someone by volunteering. Andy sends out emails every now and again where we have virtual clinics. All you have to do is call the client, use our software to help fill out these documents, and then we arrange the actual execution of the documents. But even if you're doing it that way, it's still important to have a conversation with a client. So if you're doing it that way, we'll usually I mean, we're vetting the clients on the front end. They have to go through an application process. They have to meet certain criteria. In order to be eligible for the pro bono, they usually have to meet a income criteria. And uh, so we've already kind of touched base with them, but it's important as the drafter, right, as the attorney meeting this client, even if it's on the phone, start with some easy questions, and just make them open-ended questions, right? Like, I think it's important to just kind of, one, you're building rapport with your client. You know, I'm the attorney, but you're my client. Let's see what's going on. Why do you want these documents? Has anything happened that made you think about these documents in particular? How did you hear about getting them? Um, it also it makes sure that your client knows what, year it is that they have the capacity. I would also say, to the best of your ability, have this conversation one-on-one. And again, we'll talk about that a little bit when we talk about kind of some of the ethical stuff. But uh, elder abuse and elder exploitation is huge. It happens. It's very rampant. And I cannot tell you the number of documents that I've seen, legal documents drafted by and executed with in the presence of an attorney, in which the perpetrator was present with that client. And now the client is being abused by the perpetrator. And so we'll talk about it a little bit more, but that's still your client, right? That's who your client is. I also would encourage, don't use legal jargon when you're asking for those clients' wishes. Ask it in a way that makes sense. So, you know how confusing everything was in law school. Don't say springing or non-springing. Ask, when do you want this document to take effect? Do you want it to take effect today when we sign it, or do you want to take effect when you can no longer make decisions for yourself? And I think using hypotheticals is the easiest way for me. Maybe it's not for you, but thinking through with your client, what if, what if, and that makes it a little more tangible for them. By staying curious, when you're engaging with your clients, it allows you to kind of meet them where they are. You find out what it is that they need. A lot of people use words interchangeably. They might be talking about an advance directive, but they keep saying power of attorney or medical power of attorney. They may be talking about a will, but they're referring to a deed. So again, having this conversation, just starting kind of easy softball questions, kind of getting to know the client, just a short little time. That little bit of time that you spend talking to the client allows you to kind of open up to make sure that you're getting all the information and you're meeting those clients' needs. And also, even through our own vetting process, by the time it gets to an attorney, there's always things that seem to pop up with your client. And so by having these conversations, you can find out if there are going to be potential issues that you need to think through when you're drafting, or what potential solutions you might need. And in some cases, one of these three or all of these three documents may not be the solution. But we're not going to know that until we start having these conversations. And also, I think to some extent serves as an undue influence detection, right? So in my experience, individuals who are victims of exploitation or abuse generally do not want their abusers to get in trouble. But I think that there's times, and it seems to me most people can feel those red flags when they know that there's someone who is kind of encouraging this thing to happen. So if your client keeps talking about how their daughter wants this document, the daughter keeps controlling, listen to that and follow up with that, and just make sure that there's not something more to it when you're preparing these documents. Also, and I know I've already talked about, but these one-on-one conversations do help you get a sense of the client's level of understanding, which we're going to talk about later on, kind of figuring out what happens when you encounter somebody who doesn't really know what's going on. So meeting these clients' needs, listening, that's what's happening in these conversations. You're asking a question and then you're actually listening to the answer, not waiting to keep on talking. Providing advice. It sounds like you need a power of attorney and an advance directive or will. So that's your first set of advice, right? And then you're getting the information to draft those documents. And again, if you're pro bonoing through SNSC Legal Services, we have the software in place to help you plug in the answers. I've also created a script that helps me capture all the information as I go through a conversation with a client. So you're going to get all that, capture that information, put it into paper, execute the document, whether you're doing that or if you're doing it through us, if we're doing it. And then there's like that extra step of providing follow-up advice. What are you supposed to do with these documents once you get them signed? You just give them to the client and let them walk out the door? So it's going to be important to set them up for success, that they don't lose these documents, or that their agents have no idea when it comes time that they need to use these documents. So we're talking about all those. So getting into the documents themselves, what we're covering today is truly power of attorney, or a durable general power of attorney. I'll touch a little bit about limited, but and that the statutes about the power of attorney can be found in chapter 34. The medical advance directive, right? So there's a couple of different places you'll find in the TCA that refer to medical, like a durable medical power of attorney or a power of attorney of healthcare. I think various decision makers, legislatures, the different medical lobbyists really push to have something that's simplified that makes it easier on the receiving end of these documents. So the advance directive is the form that we're going to be talking about today, and then just a simple will. And all of the will construction stuff is in a completely different chapter of the TCA. But we're going to talk about just kind of those basics. And again, the perspective I'm coming from are indigent clients who generally, they might own their home, but they probably don't have more than 5, 6, no more than 10 grand worth of property. And it's not going to be complex to distribute. And so that's why we're looking at just a very plain and simple will, not anything too fancy or too complex. So real quick on the ethical level, and this is where what you might start coming into when you have that first conversation with your client and you're talking to them and you're realizing you're trying to get a sense that they have the ability to make decisions for themselves. And it's okay. I think this is important to say that it's okay that they have that they're not 100% there. Like so this idea of diminished capacity, I think that where we come into play, where the tricky thing is kind of understanding what's happening and why. Is it just a short-term memory loss thing? Does this person have a UTI? A lot of people don't realize that with older individuals, certain types of infection will actually make it seem like they have dementia and they just need some antibiotics. Is it a type of thing where in the morning they're on top of it, they remember things, but by the afternoon they're just kind of wiped? So you really kind of have to get a sense of your client. And then these are the rules, the professional conduct rules, right? So rule 1.14, when you have a client with diminished capacity, and I include this because I am going to talk a little bit again about who's our client and who we're talking about. But if you, as the attorney, reasonably believe, I'm reading from B, that the client has diminished capacity and is at risk, right? There's two parts, not just diminished capacity, but is at risk of substantial physical, financial, and other harm unless action is taken and cannot adequately act on their own, then you can take steps, including consulting their family members. And the reason I say this is that, again, I have many people. I had an attorney yesterday, person who is licensed to practice law in this state, who said, I need a power of attorney for my dad. And I said, that's fine, but get your dad to call me. And he said, no, I just need to get it. That's not how this works. So this is where I'm saying, like, all right, we'll talk about who our client is, but the client is the individual who is issuing the authority. So there can be other people in the room talking, listening, but the client is the decision maker. And if you have any trouble with this, like this capacity, we're going to talk about it. There's some steps we can take to protect ourselves as attorney, but that person is still your client, even if they have some level of diminished capacity. Now, in the state of Tennessee, Court of Appeals said that when it comes to power of attorney executions, essentially the same and equates to the mental capacity required to enter a contract. And it doesn't even say like a complex contract. It doesn't mean to say, most people, I think even little kids say, you do this, I do this, we have a contract. That's where, I mean, that's a fairly low bar as far as what kind of capacity you have. And so if you have a client who maybe has short-term memory loss, but they know that they want their spouse to be their medical decision maker, or they know that their daughter is the one that takes them everywhere and their daughter has had problems talking to doctors, even if they don't remember all of the things, that they still have that level of capacity. What should we do as attorneys if we encounter these potential hiccups when you're like, is there capacity? What's going on? Sometimes it's as simple as rescheduling a visit. Hey, we were talking and I'm actually, whether, you kind of feel it out, set it up if you need to reschedule it on your end, or just say, it doesn't seem like you're feeling very good today. Maybe did you not have a good night's sleep? How are you feeling? Why don't we reschedule this for another day? And is there a better time that maybe we could talk? There is, and Andy, I shared with it like secondhand, so I don't know if he may have to put this on after the presentation, but there is a worksheet that the ABA created that we've modified that's fillable, and it's like 4 or 5 pages. Actually, maybe I can probably pull it up where you can. No, I can't.
All of the documents you sent me have been uploaded into the Dropbox.
Did I send you a second email, or
Yes,
is that
and
in my
they're in
head?
there too.
And that's in there? Okay,
Yep.
cool. So if you're at a computer and it's easy for you, you can pull it up, but it's a fillable worksheet that has all these questions that gives you, and what I do sometimes is if I feel like I'm a little on the fence, like I'm pretty sure that'll be okay, I'll complete these and put this in the case file. It's just to cover my butt later. To just say these were my concerns. This person was saying this person was saying this, they asked the same question 10 times over, whatever it is, and then I just document that. If there's another family member, like a spouse is in there with them, um, I mean, you can say, "Hey, it doesn't seem like this is a good day. Does this seem normal? Like, are these kinds of answers normal?" And then ultimately, oops, you can request a doctor's note, and we do that often when we have clients. And part of the reason we do that is that this is kind of the road, the kind of the fork in the road. If somebody is no longer has capacity and truly cannot be making their own decisions, but the family member says, "Well, it's going to be easy if they just get a power of attorney, so I can help them." Make sure they have that capacity, and if it takes them going to a doctor to say yes capacity, no capacity, and then bring that back, again, that's a way to just make sure that you know what's going on and you have that kind of protection in place. I tell people that it's for their own protection. For if family members contest things later down the road, they can say, look, the doctor said everything was fine at that moment. It was good. And so don't be afraid to do that. So getting into our actual documents, I was checking my time. The first one is the advanced directive, and I've screenshot. This is a form that is available on the Tennessee Department of Health. And actually, there is another link. I think, Andy, if you could share that link to that to Tennessee Department of Health. I find that there's several resources available on the website that Andy's about to share about um, it's targeted. In my mind, it looks more for information for medical professionals. And I think that's really valuable as an attorney to kind of think through, what is this document doing once it's in the wild, right? So once you release this document, the person signs it and they take it to their doctors, what's going on with it? And so they actually have, there's a PowerPoint on that website that's explaining. So it's my understanding that medical facilities, when they are doing a new inpatient, they are required to ask, do you have an advanced directive for healthcare? And the reason they do that is because the hospital can't be making decisions for people. If they can't make a decision, if the patient cannot make a decision for themselves, they need to appoint a person who's going to do it. So again, going back to the dignity, going back to autonomy, going back to that you get to make your own decisions, this advanced directive for healthcare, I think is phenomenal for that. Now, let me see, actually, I was going to pull up the actual document. Excuse me, and then I'll pull it over here. Just to review a few things that I want you to be mindful of. First, there's the primary agent and the successor agent. You're naming the first person and the second person, and the reason you're putting that contact information is for the medical facility or medical professionals to call and follow up. And you'll see in the successor language, it says refuses to serve or otherwise does not act. Let's say the primary agent's on vacation and the medical professional not get a hold of them. They're going to jump down to that successor agent. That's what's going to happen. So when you're talking, I have clients that will say, well, I want them to have equal power. And I always let them know, well, if a doctor has to make a hard decision, there has to basically be a vote, and there has to be a primary designated. And that's how I kind of force that with them. Like, you're going to cause more problems by having co-agents. I've also had someone, we've added tertiary agents in the event these first two can't. We have a third person that can jump in and make a decision. If you do add that, just make that language very clear. If so-and-so and so-and-so can't serve, then this person can serve. This allows for the person to make that decision again, like springing or non-springing. Do you want to make this take effect today when we sign it, or do you want it to take effect when you no longer have capacity? And that will require a doctor's note. And then going through these quality of life wishes. Sometimes, not all the time, but sometimes, if the client has the ability, I will provide this document in advance so they can talk about it with their decision makers because these are hard things. And I cannot tell you the number of times, like we have a box of tissues in our conference room because I cannot tell you the number of times we'll start going through this document and I have clients burst into tears because this is heavy-handed stuff to talk about. What do you want to do if you're in a coma? What do you want to do if you're permanently unconscious? And I think the language in again, this is pulled ours, the document I'm sharing is the um, kind of standard format that we have, but we just pulled it and modified it slightly from the Department of Health website. And so it explains in there, like, for example, if you're dependent in all activities of daily living, you can't talk, you can't communicate. And so it explains. And then the individual checks yes or no. How do you, these are conditions. So when I explain it to them, I say, we're going to think about it two different ways. You have your conditions. You're saying this is what how I do want to exist, or I do not want to exist in these conditions. And then there's treatments, which I always try and tease them out separate because I'll have people that'll say, I do not want to be in a coma, but if I need to have, you know, a respirator or a ventilator, then I want that. And that's why it's broken down the way it is, right? So the top half is our conditions, the bottom half are the treatments. Do you want CPR? Do you want artificial support? Do you want treatment of new conditions or tube feeding or IV fluids? And another practical thing, I guess, tip would be talk to someone in the medical profession if you are confused about any of these statuses. My husband is a nurse at a cancer center, and so he knows about all of this stuff, and I am grossed out by all things medical. So he was able to explain to me kind of what this means and what this means on the medical side, and I'm able to convey that better. Um, and if you don't know anyone in the medical field, I will volunteer my husband to talk to you. That's just how that is. Other instructions, sometimes people can write out things, but again, this is what this document is I call it like a guiding document. Ideally, your agent, if you're executing this document, you've already talked to your agent about your wishes. This is just memorializing it in writing, giving your decision makers their guidance, making sure the hospital has their decision makers in place. Doctors are not going to look at this and make a decision based on what you check. Your decision maker is looking at this and making those decisions based on what you check. They have options to select for organ donation, if they have burials, cremations, and then the signatures. This is one of the documents where it's either or. You can either have two witnesses or notarize it. We are very heavy-handed here at West Tennessee Legal Services, and we do both of those things at the same time. Just to no one's going to question these documents. Is all. Excuse me. And then at the bottom it says what to do, which we'll talk about. Give a copy to your doctors. Give a copy. Keep a copy where it's going to be accessible. Tell the people who are going to be your decision makers, this is where the copy is. I try to assist with if people need scans of the document. I keep my own personal documents on my email. In the event of an emergency, I can just pull it up like it's attached to an email. I pull it up, I can send it to whoever I'm like, whether I'm checking in somewhere. Here's my power of attorney. Here's my advance directive over my husband. Okay. So if a person does not have those documents, there are alternatives. They're kind of a short list, but again, hospitals are not in the business of making decisions over for people. They want to appoint someone. So there is a post document that is going to be completed by a physician. So if someone rolls in with no advance directive, but they're going to have some procedures done or at risk for, someone's going to need to make a decision, there is this document that's available online. There is also a durable healthcare power of attorney, which is a little more involved. And I've had someone told me once that they weren't able to check into a nursing home without it. But if you look at the history of the healthcare power of attorney and you look at kind of the medical facilities, the preference, in my understanding, the preference is the advance directive because it's a standardized document that hospitals can look at pretty clearly and understand what's going on and go from there. But there is statutory language if you are assisting a client. And again, this isn't something that I'm covering today, but there is statutory language about what should and should not be included in a durable healthcare power of attorney. Going on to our next one, keeping an eye on the time. So, the second document, when people call in, almost always when someone calls in, they call and ask for the one document. They'll say, I need a living will, or they'll call in, they say, I need a power of attorney. Or they call in and just say, I need a will. And then I always let them know, as part of thinking through this end of life planning, we offer these three documents all together. And we do it whether it's through the clinic, through the pro bono program, or sometimes my grant allows me to go to like homebound or institutionalized individuals who can't physically make it to an attorney's office. And so they'll call in, they'll say, I need advance directive. I'm like, well, while we're at it, do you want me to do power of attorney and will for you? And so this is the second document in our list, the durable power of attorney. And just for a refresher, for those that don't know, the principal is the person who is giving the powers. The attorney, in fact, or sometimes called the agent, is the person who has the authority to make those decisions. And this comes, Andy shared it with me from maybe Takis McGinnis, I think, is the ones who maybe planted the seed in his head, and I don't know where they got it. But the idea of using the language of sharing authority is, again, provides that dignity and autonomy to the individual. You're not giving your authority to somebody, you're sharing your authority. Because as it turns out, you can also take this back. If you still have capacity, you can share your authority and you can revoke that authority. And so just being mindful of the language that we use when we talk to clients. So a durable power of attorney, the durable language refers to that subsequent disability or incapacity. So it means it's going to be durable even if the individual no longer can make decisions for themselves. And if you look at the statutes, and I won't go into it too much, but if you look at the statutes, there's even some potential language about a durable power of attorney versus a conservatorship. Like what ranks over each other if something was signed in advance of getting a conservatorship. So as long as there's language in it that says something about the subsequent disability or incapacity, again, TCA 34-6-102 has a little more kind of explicits on that. You want to look at it. But if that language is in there, that the presumption is that document survives, even if the person no longer has the decisions to make for themselves. And the way you do that is you get a doctor's note, and then you carry that doctor's note with the power of attorney. There are ways that you can broaden. We're going to talk about the enumerated powers in a minute, but there's ways that you can broaden powers of attorney, like make it general, very general. But there's ways that you can also make things very explicit or even super limited. And that's where we want to get that express limit language. If it's going to be a limited power of attorney, the presumption is I'm going to do what this document says, right? So that's the automatic presumption. So sometimes I helped someone, so the only thing that she wanted her daughter to be able to do was pay her bills, was withdraw money from the bank and be able to pay her bills and nothing else. And so we were very clear in that language, that was what she was allowed to do. And so that's what, that limited can be any number of things that is very explicit. And you can put a limit on the time frame that they help. You can put a limit on what they have access to, or who has the access to it. And then the general power of attorney is what we're going to talk about more. That the language for general power of attorney is in both 34-6-108 and 34-6-109. And my notes say share the next poll, but I'm trying to remember what exactly it is. So let's just see. Oh, okay. What are ways that clients might want to limit their power of attorney? I already said an example, so I was kind of cheating, but have you had experiences where someone wanted a more limited power of attorney, or can you think of ideas? Why would someone want to limit that power of attorney? And I'm opening up the poll for the group. Just FYI, I made every answer anonymous, so I don't see who's typing. I just see that people are typing or answering. So I'm going to give this a minute because I need a breather. Okay, thank you for the 4 people who are answering. I appreciate you. Somebody's listening. Oh, 6 people now. Okay, I'm gonna pull up. While you're answering, I will pull up 108 and 109. Okay. All right, I'm gonna leave like 10 more seconds on here and then I'm ready to pick back up because I think we got what, 20 minutes? I'm gonna make sure we cover all our bases. Okay. Whew. Now let's see. Oops. View details. Okay. Closing documents, good. Transfer title to vehicle, to sell real estate. The time limits, that's good. More property, not to take debt out. I love it. Excellent ideas. Okay, stop sharing, go back. I think that's on those. So, all right, moving on. So, Tennessee adopted Uniform Power of Attorney Act. And so when we're looking at our durable general power of attorney, this is language pulled from it, but without diminution, or restriction of powers vested in the attorney. In fact, the law or elsewhere in the instrument and subject to all other provisions of the instrument, the attorney, in fact, shall be vested with powers specifically enumerated in this section. I did not list all the powers. They're on, oh, let me pull it back up. Sorry. Okay. So if you have access to the Dropbox, our power of attorney enumerates powers based on language from the statute, right? And that's what this is. So the legislature enumerated the powers to very specifically say these are the things that a power of attorney is allowed to do. And that's under 109. And so, I mean, it's generally basically you are an extension of me. You get to do what I want, or yeah, do for the good of me, as if it were me. I will say, I always say this to my clients, and I remind other attorneys that when we execute a power of attorney for a client, it is a state level document. And agencies like Social Security Administration will not automatically accept it at face value. They have their own process. If that client needs assistance, there's a process to become a representative payee. You cannot just send them the power of attorney and they just accept it. So there is language in there that says I'm giving permission for Social Security to accept this document. Social Security still is not going to care about that. So that's one thing I always stop when I'm reviewing a document with clients, just take a pause, because most of my retired clients have some kind of government benefit, and if it's coming from Social Security, we just need to be mindful of that. That there's an extra step, that this is not the last thing. So now okay, so this is where, when we're looking at powers of attorney and what they can do. So if your language says, if the document says it's a power of attorney. So according to 108, oh, that was 109. I'm gonna pull back up 108. If the power of attorney document is clearly expressing an intention that you're creating a general power of attorney, there's language in it that essentially courts are allowed to construe if it doesn't neatly fit into one of these enumerated powers on 109. For the most part, attorneys, in fact, have the power to go and do things. Now, 108 there's some protections in place. So 108 down to C, we're not assuming, you can't just make gifts if there's not language in there that says make gifts. You're not allowed to do that, right? So you can't just go ahead and revoke the power of attorney. You can't, unless you're going to resign. There's really very limited things you could do as power of attorney, right? You can't just go and delegate it to someone else. Can't change the beneficiary designation on death penalties. And they do this. And again, the power of attorney may say it. If it is express language in your power of attorney, then you have the right to do it. But if it is just a general power of attorney that just says, I'm generally giving you the powers, the courts will assume you're looking at the enumerated powers in 109, but you do not automatically get the powers that are kind of excluded here in 108. And I think that's kind of important, particularly, and I do a lot with like elder abuse and elder protection, and kind of looking at where the power of attorney rests, who has the authority, what is their authority, is really important. So again, it goes back to that conversation that you're having with your client. What do you want? Why do you want them to have the power of attorney? How much authority should they have? Do you trust this person? How long have you known this person? Very important questions. Yeah, and I think those are of value, knowing what they can and cannot do. So, in the event, and actually I'll say before I finish, I was talking about best practices. When I review a power of attorney document with my client, I start with the warning of a power of attorney. So our document automatically has a warning on the very last page, and it has things that say, this is a very powerful document. This document is sharing authority that everything you can do, this person's allowed to do. And I start with that. And one of the things that's very clear in there, it says you have the right to revoke this power of attorney, but it must be in writing. So I always encourage clients, you are allowed to change your mind. Things aren't going the way you want them to. You've decided someone else should be your agent. It's just not working for you the way you thought it was. Please know that you have the right to revoke your power of attorney. It has to be in writing, so they can write something out. We all love it when clients go and do their own legal work. I encourage clients to come and talk to us if they do want that. But I think it's important to, as the attorney, if someone comes to you, or if you're, if you think you're dealing with elder exploitation, elder abuse, the best practice, in my opinion, is to update and execute a new power of attorney, right? Get a new agent in place. Maybe make it a springing document, right? Make it so that in the future, only if incapacitated, that person can have authority. But if they truly do not want, I put the document in there, if they truly do not want an agent, they take a break, they just want to revoke the current power of attorney. In the Dropbox, there is a sample form of a revocation of power of attorney. We treat it like power of attorney. We want it witnessed. If there is a power of attorney that you're revoking, best practice, attach your revocation to that power of attorney. And also notify all the places who have that revoked power of attorney, go and submit them. If you know it's a bank that was using them, send them the revocation with the attached power of attorney. If we'll send it to the perpetrators. We'll say, hey, BT Dubs, you are not allowed to take action anymore. And here's the revocation that says that you cannot take action anymore. So because if there's just these like floating power of attorneys out there, and clients revoked it in writing, but the agencies who have the document don't know, what are you going to do? And outside of bad faith, power of attorney documents, there's not a lot of, like, banks can't be held accountable if they didn't know about a revocation. So agents can't be held accountable if they didn't know about the revocation. So it's just something that's why it's very important to, not only get this document in writing, submit it, and just kind of, do the best you can to let people know and gather up those extra copies. Simple will, and this is, again, very simple document. Again, talking about clients who are generally right at the poverty line, maybe are not allowed to have more than $10,000 worth of personal property and under our, the grant that works for pro bono. So generally have very limited resources, very limited assets. And so I have a script. I won't go over it, but there is a suggested script in that Dropbox materials. And it is something I just kind of created for me to remind myself, make sure I'm asking all the right questions as I go through, capturing all the information, because I don't really want to call back and be like, oh, wait, what about this? Oh, wait, what about this? But the big questions when you're asking our clients. And so what I do is I say, hey, I understand you want to get a will, power of attorney advance directive. Here's the information I'm going to need from you. I'm not getting it from you right now. I'm telling you in advance, and we're going to set a time to talk about it. And I do that so that I can give them a little heads up. This is the information I need from you. I'm going to need, oops, I didn't talk about it, but I need to know the who and the what and the how. Generally for beneficiaries and executors, I just need their names, full names and spellings. I forgot to say it back. The only time that I need their addresses is for the advance directive. And I meant to talk about that. And that's again for the hospital to be able to contact them. So I actually have that language in my script. Okay, so who, when we're thinking through, when I talk to my clients, so who do you want to get your stuff? And how, and who do you want to decide who's going to get your stuff? And so again, so I'll call them on my first call. I'll say, okay, here's the information I'm going to get from you. I don't want you to make a decision today. I'm setting a time for like Tuesday at 4. It's probably going to take half an hour. Okay, cool. We'll talk then. But these are the things I want you to think about. And that way too, if they don't have, like, let's say they don't have someone's street address, they don't have a phone number, if they want to confirm that someone wants to serve as an executor, it gives them that time to do it. So who's your beneficiary? Who's going to be your executor? Then our next steps, do you have any real property? And we have 2 separate simple wills. Again, generally, most pro bono clients are not qualifying with real property in their home, but if they do have real property, we have a clause for the real property. The personal property is the stuff. And really kind of thinking through that, how do you want to distribute it? Do you want to gift it as it is? Do you want to sell it and then give the proceeds? Um, and then this is the big one. What happens if your beneficiary dies before you or with you? And this might be when your hypothetical is coming in, because some people, it's too much to think one way or the other. So, I will often say, what about, you know, if you both got in a car wreck on the same day, where instead of going to that person, do you want it to go to their heirs, their children? Do you want it to go to the other beneficiary? Do you want to name it a totally different person? And then I have this question on here about bond. Uh, I don't think I have yet to have anybody who says a bond, but it's allowed, unless it's explicit in the will. And what I explain to clients is I basically say, do you want someone to pay money out of their own pocket to like basically like an insurance policy to serve as your executor? Most of my clients are thinking through, they don't have money as it is. It's like, no. But I do ask that, do you want a bond, essentially, so that we don't generally have that language in our will, but it's there, just in case. So, um, thinking through beneficiaries, the beneficiary is not going to be someone you're going to have serving as a witness to the execution of the will. If it's someone under the age of 18, you might want to communicate. It doesn't have to be in writing, because what it says it says that the executor can appoint the guardian of the property until that child turns 18, right? So again, this is thinking through simple wills. If you're looking at more complex situations, then that's like the next level class of this. But just if there is someone, again, communicating, who would you want to be serving as that? Do you want the executor to serve? Do you want someone else to serve? You can include that language in there just as long as the executor knows, because ultimately the executor gets to make that decision. And the beneficiaries can be more than one person. And then you kind of ask, like, how do you want to distribute that? Do you want it to go equally across? Is one person going to get more? How's this going to look? I can't remember what I was listening to, and it could have even been through law school, but someone was telling me when they draft law school, when they draft wills, it's a really, you think about like everyone dying. Like you're like, it's almost like playing like a video game, and just like everyone's dying. And then you have to think who's left. And it seems very dark, but legally, truly, what are we doing? Right? So per stirpes, if you forgot from the law school time, that means kind of the automatic heirs. So do you want it to go to those automatic heirs, or is there someone else you want to give this to? Right? So do you want it to go to the other beneficiary? Do you want it to go to a different beneficiary? How do you want this to go in the event someone cannot receive their portion? And that's, again, helping. Hypotheticals are the best, right? Just let's talk about this as if, and for some people, keeping it light it just makes it much more manageable to have these conversations. Checking my time, just a few more minutes. Oh no. Right quick, drafting the language, you want to be clear. If you're using the Documate software, which is now called Gavel, it is going to automatically populate what you need. But if there's things that you're going to be changing in that document, make sure you're being very clear. If you do not clarify an answer from the client, call them back. Do not assume what's going to happen, and be mindful of like specific properties. So when they say something like, I want to, my 1997 Honda, whatever, I want to, just be mindful. What happens if you have to sell that car? What happens if it's broken? What happens if, something happens before it goes? Just be mindful of if there are specific bequests, what's that going to look at. Whenever I deviate from our standard language, I have a colleague just kind of review it and read it and then tell me what they think it means, just to make sure that, like, because I think sometimes we can think it means something, having another set of eyes is really helpful. And again, if you're going through our program, it's probably gonna go through another set of eyes, during that execution stage. And then don't forget those restraints on alienations. When you have a client that says, "I wanna leave everything to my girlfriend, but she's never allowed to get married again," can't do it. Just you have to be mindful. There's some things you cannot do when you're drafting a will. It's against public policy, and there's case law on it. So if you have something that comes up that doesn't sound right, shoot a question over to Andy or me. Um, do some legal research. But yeah, there's some things that wills you can put it in there if you want, but it's not going to be enforceable. Being mindful of executing the documents. So this is, again, if you're doing it through our pro bono program, generally what you're doing is almost everything up until this point, right? You're talking to the client, you're drafting the documents, making sure their wishes are met, and then we end up orchestrating, for the most part, the executing of the documents. But if you're doing these executing of the documents, make sure that they have the capacity at the time of signing, right? They could have had capacity when they were talking to you about everything, and then the day they come in and sign, they don't have capacity, then you need a rescheduling, you need to go back through that process. Um, in most of these documents, you do notary or the two witnesses. What we do is all of them because it just seems to cover everything a whole lot better. Make sure your witnesses are unrelated and uninterested, right? They're not going to be receiving anything. They're not being any decisions. They're not related by blood, by marriage, by adoption. There is no relation at all. They can't be financially responsible for the individual, right? So if they're a witness, they can't be, or they're not going to be named as a power of attorney. They can't be over the medical decisions when it comes to financial spending. And as far as that advanced directives, it cannot be the attending physician. So actually, we end up sometimes I go to hospitals to meet clients kind of who are bedbound or on the end of things. And a lot of medical facilities straight up just say no one can be a witness at our facility, and it's because they're just basically avoiding this conflict. This sounds very silly, but it's true. Your witness has to be in the same room while the signing is happening, and they have to watch the signing. They're they can't walking away like, yeah, he signed it while you're in the bathroom. They has to actually serve as witnesses for real. Um, Meet the client where they are when you're reviewing the documents. I think I was supposed to do this one before the execution, but neither here nor there. Figuratively, right? You don't have to oversimplify. You don't have to infantile the client, but talk to them, right? As you're going through the document, make sure they understand what each thing means. Um, Again, I'm on the receiving end of people who have been exploited using legal documents and who have told me the attorney said this. The attorney said this. They didn't know what they were signing. And they just said this was going to help me and my daughter pay taxes on my home. I didn't know it meant she could sell my home. So that's why go through, don't rush. Make sure your client, one on one, your client is the person who is executing this document, right? So if there's other parties involved, like, see ya, bye. Um, we want to make sure it's just the client and they understand the authority that they're sharing. Allow for those questions or any kinds of concerns. Don't be afraid to make a second appointment. I'm very busy. You're very busy. We're attorneys. We're all very busy, but it's okay to say, you know what, how about we make some changes and revisit this? And then maybe have a plan to update. So again, it could be that to reset a time. We've got a pretty easy setup, at least physically in our building, that if I need to make some changes that are like maybe the name is spelled incorrectly or something, we can go and make those changes while the client's waiting. So just be flexible at that point to allow that to happen. And then that advice, kind of that secondary advice, um, you could just send all these documents on their way out the door with the client with not telling them anything, but that's not really going to be super helpful down the road when their family members are like, where the heck are these documents? So let them know you want to keep this in a safe place. You want to let people know that this is in a safe place. Ask them who's going to have copies of the documents. You really want your agents to have those copies. Again, I try and encourage, I'll send you an encrypted email with a scanned version of the documents. Letting them know if you have a scanner at home, scanning it's great. Copies can be stored. It's cool if you have a lockbox, but if no one knows how to get there and the document that gives them authority to access the lockbox is in your lockbox, not going to help you. Agents should understand their responsibilities. So, oh, I have 1 minute. And I put a plug in, and Andy, if you could share that last link, if you haven't already, or there's 2 more links, but the CFPB, they have these really cool books about managing other people's money that gives those agents kind of the authority and rights and understanding of what they need to do. And make sure that they know they have to keep their money separate from the your client's money. We just want to keep everything clean and on the up and up. Reminding them they have the option to revoke these documents, reminding them if things change, if your agent moves away, if you want to make changes, come back. And then I just put this in here because, and then this will be the end, Andy, I promise. But there is, if you're not familiar with Alzheimer's Tennessee, they have some amazing resources for family members and caregivers who are dealing with people, whether it's full Alzheimer's or even early stages of dementia. And so if you don't know about that Silver Alert Kit, that is very, very much so a part of this whole advanced planning thing. So reach out to them. It's free. It's a whole thing where you can get all the information for your loved one as they advance mentally and their cognitive capacity declines. In the event they wander, this is an excellent resource to capture all that information and give it to law enforcement, and it's free. So it's across the state. So I encourage everyone to reach out to them if you're caring for a loved one as well. So that ends that. Thank you for listening to me. I hope I covered everything, and sorry for going almost 1 minute over.
Great. Thanks, Elizabeth. That is the end of our seminar. Everyone should have received an email with the information, with the link to get your CLE credit. It's also posted in the chat. I will be sending another email out with that just in case for everyone. And if you don't get that, feel free to reach out. But thank you all for attending. And if you're interested in volunteering either in this clinic with the Wilson POA clinic, we do have one coming up next month, and you can sign up for that on the CLE form as well. But if y'all have any questions, feel free to reach out and have a good day.